I do not believe there is a state of the world in which bump stocks do not get heard by the Supreme Court. We are the Arms Attorneys. Today we're talking to you about the latest installment of the bump stock saga that has been playing out over the last several years. Some good news here for gun owners and some good, I think, crystal balling we can do for what's going to happen to bump stocks going forward, heading towards the Supreme Court. But before we get started, show your support for the Second Amendment by hitting the like button.
And in today's video, we're talking about Scott A. Hardin versus the Bureau of Alcohol, Tobacco, and Firearms. And the issue before the court here, and this is in the Sixth Circuit Court of Appeals before them, was whether a bump stock was a machine gun part for purposes of 18 U.S.C. 922. Now, we have this general prohibition under 18 U.S.C. 922 about possessing, transferring, or receiving machine gun parts, and they say this part is a machine gun for purposes of the National Firearms Act.
Right. The bump stock itself is a machine gun
Yep.
under what the ATF would like to impose upon us.
This is what makes this a little bit hinky because we have the Congress has defined what a machine gun is.
Mhm.
The ATF came in behind them, and for a very long period of time, we had mirrored definitions of machine guns. But as part of their final rule on bump stocks, we saw this under the Trump administration. They expanded the definition by administrative fiat of what included the machine gun. So that kind of catches everybody up. Now, we've had challenges going on all over the United States, and this is just the latest one.
Yes. And I think this first of all, the Sixth Circuit really surprised me here because you kind of get to expect this sort of thing out of maybe the Fifth Circuit.
Right.
Sixth Circuit, not so much. So they made a very well-reasoned, simple argument in favor of bump stocks not being machine guns. And I'm going to take the lawyeries out of it and just spit it out because it's very, very good. But here we go, because it does get a little complicated. So step one. Is this statute defining machine guns ambiguous? The plaintiffs here, right? So that is Mr. Hardin, who wants to have his bump stock, says, essentially no one's arguing it's ambiguous, right? We're saying either no, hell no, it's not a machine gun, or the ATF is saying absolutely, and there's no ambiguity. If there is ambiguity, though, generally you would apply something called Chevron deference. And interestingly, neither party is arguing that Chevron deference should be applied here.
No, and the court even says we're not going to apply Chevron because typically you would leave an administrative agency to interpret some kind of specialized knowledge that agency might have inside of what they regulate, like the EPA regulating some really nuanced regulatory scheme with regard to the environment. But here we're talking about criminal law.
Right, and so that's the thing. So to have Chevron deference, first of all, you have to have ambiguity, which basically neither of the parties here are alleging any ambiguity. Which the court actually is like, well, it doesn't make sense because even the ATF itself has changed its mind on bump stocks. So the court basically says there is ambiguity here. However, we can't apply Chevron because you don't get to apply Chevron to a criminal statute. So what then happens, Richard?
So the Sixth Circuit in this case moves on to lenity. The rule of lenity is essentially, especially when it comes to criminal law, because we're entitled to due process rights as, American citizens, people being prosecuted under the laws of the United States, we have to be on notice of what laws govern our conduct. And so whenever we have maybe something that wouldn't put us on notice or something that would be, I hate to pull the word ambiguous again, but
you have to. That's what we're coming down to.
When the government kind of messes up in either drafting or whenever they're changing these rules, we say error in favor of the petitioner, in this case, the defendant. We give them the benefit of the doubt because how are they supposed to know how to govern themselves?
Exactly. When something is ambiguous, you must interpret, right? If a law is ambiguous and it's a criminal law, you must interpret that ambiguous law in the favor of the criminally accused, because otherwise, the government would have no reason not to just craft these really, really highly ambiguous laws that they get to enforce, arbitrarily against whomever they choose. Now, lots would argue they already do that.
Yeah.
But it would be way
at you, conspiracy. Conspiracy to commit anything.
Right. Yes. It would be way, way worse. So it's a tight opinion. It's very good. It's very well reasoned. Actually, even the concurrence is interesting. I don't know if you got all the way through that. A lot of times as lawyers, we go, we don't need your concurrence because it has no legal holding, but or no legal bearing. But even if you read the concurrence in this, you've got the concurring judge saying, look, I mean, I agree with this holding, but I disagree that it's even ambiguous. There's no way a bump stock could ever be a machine gun. I don't even think we get to any ambiguity here. It's just wrong, which is also very interesting to me.
Yeah, but I think this sets the perfect stage. And we were talking about this off camera. You know, I don't think we imagine a scenario where the Supreme Court doesn't take this case
No.
up.
I will, and it's hard to do this on videos, but I'm going to do it. There is no state of the world in which the Supreme Court does not take up the bump stock issue. Cut to 9 months from now when they deny certiorari.
Yeah.
But no, but
Save this clip. We got to have
Save it.
The regret roll.
I'm going on record. I do not believe there is a state of the world in which bump stocks do not get heard by the Supreme Court.
Yeah, and so we have, just by way of example, we have Patrick versus the ATF. That's our Fourth Circuit case. Potion v. Garland, that was out of the 10th Circuit that originated in Utah. McCutcheons v. the U.S. that originated, I believe, out of Florida.
Those are our bad ones.
Those are bad ones. And I believe there's a District of Columbia case floating around out there as well. But then we have this case that we just talked about, Hardin and Cargill v. Garland, and this is out of the Fifth Circuit Court of Appeals. Now, there's been a new development with the Michael Cargill case, that Fifth Circuit bump stock case that they struck down the bump stock ban. What's going on with that?
Well, the government has appealed. So the government has asked the Supreme Court to take it up by writ of certiorari, which surprised some people. I was not that surprised by it, though.
I'll say I was surprised by it.
Really? The federal government's gonna federal government. They really, I think they believe in their heart of hearts that this is a winner for them.
Well, and I will say the decision to appeal the Cargill case came pretty soon after this decision in the Hardin case. And so, usually when you're the government, you want to appeal what will be your strongest case. Personally, the Cargill case is pretty airtight.
I know.
And so I don't know why they would pick such a strong case to appeal personally. Maybe they didn't know this was coming.
Please leave us a comment. I am genuinely curious what you guys think. Why was the Cargill case appealed by the government? What is going to happen going forward? Are you as optimistic as I am?
Are you middle of the road? You hanging out with me on the fence?
No, but please leave us a comment. Let us know. This is, a genuinely very exciting issue for attorneys, which is, say what you will about our lives when that's the case, but it's very true.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please leave us those comments below. Until next time, we're the Armed Attorneys.